A man named William Michener died in Queensland in June 1918, and from the context we can assume that he probably knew the end was coming, because in April 1918, just a few weeks before his death, he made a will. For that purpose, he asked his executors to provide money from his estate to the German consul in Australia, who would then arrange its distribution overseas. Under that will, he wanted to make various gifts to beneficiaries who were located in Germany. However, there was a problem with this. Due to the First World War, which did not end until November 1918, there was no German consul in Australia, and one was not likely to be appointed anytime soon. Furthermore, it was not lawful to send money or resources to Germany, an enemy nation, without special permission, which would not be granted in this case. The court therefore had to work out whether the gift failed and what would happen to the money. The court's ultimate finding was that the will had intended to make an immediate gift of the money to the various beneficiaries in Germany, and that the engagement of the consul was merely a proposed mechanism for the payment of the money to the beneficiaries. As a result, the gift had been successful. The parties in Germany were now the beneficial owners of the gifts made to them under the will, but the proposed mechanism for the transfer of the funds had failed. The court therefore interpreted this situation as creating a trust under the will, and so the executors became trustees for the amounts until they could properly be paid to the recipients in Germany. Justice Higgins made some observations about the nature of trusts, and in particular trusts which were found to have been created by wills. He said that if the alleged trust merely empowered or required a person to do things, then it was not a trust at all. But where specific and identifiable property had been bequeathed under the will, a trust was entirely proper. He said a trust must be associated with property and rights to property. This case has therefore become the Australian authority for the proposition that there can be no trust without property. A trust is not merely a fiduciary relationship between two people. The trustee must actually hold property on behalf of the beneficiary.